The NLRA requires unions and employers to bargain in good faith regarding, quote, wages, hours, and other terms and conditions of employment, unquote. The three categories of bargaining subjects are mandatory, permissive, and prohibited. Suppose that, following an increase in workplace accidents, an employer unilaterally implemented a new rule requiring mandatory drug and alcohol testing for any employee who experienced an on-the-job injury requiring treatment. An employee who failed the test would be fired. The union demanded to bargain over the new rule, but the employer refused. Was the employer required to bargain? Wages, hours, and other terms and conditions of employment are mandatory bargaining subjects. Mandatory bargaining subjects are issues that resolve aspects of the employer-employee relationship. Drug and alcohol testing is a mandatory bargaining subject. Thus, the employer in the example had to bargain over its new testing policy. Other examples of mandatory subjects include sick leave, vacation time, and seniority. It's an unfair labor practice for either side to refuse to bargain over a mandatory bargaining subject. A party may lawfully bargain to impasse over a mandatory bargaining subject. Now suppose that during a strike, a union imposed fines on its members who crossed the picket line. When the union and the employer subsequently began negotiating a new CBA, the employer bargained to impasse over a proposal that the union withdraw these fines.